when's it enough to see something and then that creates an investigative attention? And I'm going to just preamble this on a quick side note where if you're talking about pedestrian stops, and you had a pedestrian violation of pedestrian traffic law, just so you're all aware, that would be enough for an investigative detention where you could compel identification because you could issue a summons for the violation. So on a quick side note, a lot of people don't know that. And guys and girls won't enforce that because they're afraid. And then, you go to the inner cities and they're enforcing that shit all day because they're coming up with great stuff. I mean, people are still going to have to get around when they're really, really wanted, or they're, they know that most cops aren't going to engage folks on a foot to, outside of a motor vehicle stop or a service call. So when you do, you catch people off guard, and the results are phenomenal. I mean, they're really great results, unbeknownst to a lot of people. So you would have that so if you see somebody thinks acting strange and they happen to jaywalk or walk against the crosswalk, the signals, or dart out into traffic and cause some kind of safety concern, whatever your law regarding pedestrian traffic in your state says, you would then have the authority to conduct an investigative detention similar to a traffic stop, right?
Oh, yeah. Yeah. But your focus is going to have to be on the violation of the law if you don't have the RS of the other criminal activity. It's just like a traffic stop. Yeah.
Right. So it's almost like a pretextual pedestrian stop.
Exactly what it sounds like to me. Yeah.
Yeah. Now, what? And again, it's such a broad question that I think we could maybe just provide a couple examples of what would be enough to stop somebody and compel ID. And I've got a few, but I'm going to give them to you first.
Well, it is a
very broad
question. And I guess I would start out with saying that reasonable suspicion is not a high standard to begin with. I mean, probable cause, what it takes to get arrested or to get a search warrant, is also not a high standard. The Supreme Court has made that clear in numerous occasions, that probable cause at its lowest level doesn't even necessarily have to be more likely than not. They said that in Illinois versus Gates and several other cases. So it's a relatively low standard, and we all know that reasonable suspicion is lower than probable cause. So to be able to stop somebody on the street, it doesn't take a lot, but it has to be something specific. And an excellent illustration of this concept of reasonable suspicion, although the term is never mentioned in the case, is Terry versus Ohio. That there clearly was no crime when Detective McFadden stopped Terry and the other two gentlemen that were with him. They had not committed a crime, but their actions that he observed, an experienced police officer observing those actions, it was reasonable for him to think that criminal activity was about to occur. They were either involved in a conspiracy at that point, or they were about to do something criminal. So that's really an excellent example. And the case lays out the facts very clearly as to what happened.
I would agree. I think Terry v. Ohio is the quintessential example of what you're looking for, and try to take that and apply it. And the only way to really know what were good factual cases where this was authorized is to read case law, man, because you're going to try to collect as many circumstances as you can and try to apply to the things you have in the field. And I don't know if you agree with this, Zach, and I think about this often when I write case law. And you could disagree. I mean, we're certainly colleagues, and I consider us both professionals, even though I hold you at a higher regard in this realm. I'm a far better lover, I'd imagine, than I don't know. Maybe not. Maybe you're just. But no. I tend to think Terry v. Ohio is probably the most important case that police officers need to familiarize themselves with overall, by hands down.
Of knowing the facts of the case, I would agree 100%. A lot of cases like Miranda versus Arizona, you don't need to know the facts. You need to know the rule that came out of it. Terry, I think you should know the facts of Terry. Yeah.
And I think Terry applies to how many cases that we look at as cops. I mean, I always think if you want to start at a place to search your state's case law, run a search against Terry v. Ohio, pull the 290 to 1,000 cases that they've had to cite Terry, and you're going to get a real good understanding of a lot of things regarding what we do as cops, and especially proactively. They're always citing Terry and the things that we kind of talk about when it talks about Fourth Amendment search and seizure, namely for patrol division officers. Would you agree with that, or is that crazy to say?
Yeah, Terry is definitely a great case for those, and a couple other ones that United States versus Socolow is a good reasonable suspicion case. Where these are cases where the court really dives into these concepts of reasonable suspicion and what it means. Alabama versus White, Florida versus JL, are some really good reasonable suspicion cases. The Glover case recently, not so much.
Mhm.
But yeah, I would definitely start with those and read the facts and what the court says about the facts and why all of those cases except JL, the court found reasonable suspicion.
Let me jump in here and just say this. We have a reasonable suspicion checklist. It's really mainly a lot of times used on a motor vehicle stop. If you are a law enforcement officer, you have a privy to having access to that. It's found in our Street Cop Training Facebook group. It's a private group for law enforcement. You could email streetcoptraining@gmail.com, but you'll have to email us from your government email address or provide identification to confirm your identity. We are not handing out our resources at free will to everybody who requests it, because it's not that it's anything illegal. It's just that we're using it as a resource to train police officers to fight crime, and that's what it's used for. So it could be a little differently, but what I always try to explain to guys to start and really build the foundation is reasonable suspicion is knowing what's normal and saying, is this normal? Does this make sense? Is what's happening here normal of somebody who's not doing something wrong? And I tell people, when you leave this when you leave this training session, you want to know what normal is, go turn your rear radar on and pull people over doing 11 over the speed limit. And when you pull them over, tell them you're not giving them a ticket. They'll generally calm down and relax from that point forward. If you took those people out of cars, which I'm not urging you to do to test run this thing, but if you happen to take those people out of cars and ask them about where they're coming from, where they're going to, a purpose of trip, relationship to people in the vehicles, you would find that it all makes sense. Passenger one knows, passenger two knows. They have a good explanation. It's in their GPS and their phones. Why they have this amount of money? Maybe they have a bank receipt, and there's no nervous behavior. They're very, very calm and sure. I'm not getting a ticket. I'll tell you anything you need to know. And then the latter. Then you find yourself in a situation where none of this makes sense. There must be something weird going on here. And again, please, if you're listening to this, interpret as I'm trying to give you a basis understanding of how to know or discern the difference between something that's non-criminal versus criminal. I'm not saying a violation versus a non-violation. I'm talking about criminal circumstances versus non-criminal circumstances. A guy standing in a crowd, maybe watching a cheer routine of Pop Warner cheerleaders, right? And he's filming the cheer routine with his cell phone, but his daughter's there, his wife next to him, and his kids are holding on to him and they're playing, and you pay attention, and he's clearly the dad of this girl. It's very different than a gentleman who's on the other side of the field who is recording Pop Warner cheerleaders, who is recording it and kind of has sunglasses on, maybe a hood over his head, is trying to keep a low profile and seems to discreetly be recording this. I haven't seen any engagement with anybody on that Pop Warner cheerleader team, and we can conclude that this dude is up to no good. Or you'd at least try to come to that. And again, like Zach said, the prerequisite that you need to initiate an investigative detention, the question is, what law is he violating? Number one, do we have enough here? And number two, just so everybody knows, when you have circumstances like this, even the most liberal courts don't like people hunting children or recording children. So, it's very different when you think about what's normal, what's not. And that's really the name of the game, how to be a cop overall. So would you agree with that? Do you want to elaborate on that any further?
Yeah, I mean, just by spending a little bit of time observing people in your daily environment, you develop a baseline of normal behavior, not normal, non-criminal, everyday behavior. And just at one point, I guess I wanted to make about this, how specific of an offense do we have to be suspicious of before we can stop the person? Meaning, do I have to point to a specific violation of the state code that I'm looking to enforce before I can stop the person? And the majority view nationwide is no. It's just reasonable suspicion of illegal activity in general that would suffice for reasonable suspicion. Now, there are some courts that I have seen that no, you need to pinpoint a specific offense that you're suspicious of, but that's not anywhere near the majority. So yeah, we don't necessarily have to say we think he is getting ready to do this particular crime, or he's involved in this particular crime.
Yeah, New Jersey is one of those states. We actually had a case where somebody was arrested because the cop knew something was wrong, told him one thing on the scene, went back and read the book later and charged him with another thing. And the court said, well, you didn't know what he was. Yeah, the defense was, you didn't know what you were charging for. And the court said he knew something was wrong. Him misciting the actual statute wasn't an incorrect thing. He still knew he had to take action.
Yeah, there's a Supreme Court case, and it escapes me right now, but the an unlawful arrest, meaning we didn't have probable cause for offense A, can be saved by having probable cause for offense B, even though the officer was unaware that B could be charged at the time. So I forget the name of the case. I apologize, but it's out there. It's a Supreme Court case on that.
Awesome. What else do we have? Anything else? I think we're getting close to the end here, right?